peace to everybody out there in YouTube land. This is Noble Moorish God coming back at you. Been a while. This is a new video I got discussing child support, alright? This is a lawsuit I did on child support back in March 16, 2005, right? Now check it out. Sultan Shaheed Pro Se versus the state of Ohio. Cause of lawsuit: unconstitutional garnishment of wages, denial of equal protection, due process, and privacy. Unconstitutional taking of property, invidious discrimination, and the denial of pursuit of happiness. Introduction: somewhere in and around January 25th, January 2005, a court order was issued by the State of Ohio Court and Collection Agency, Ohio C.S.P.C, to garnish our petitioner, Sultan Shaheed. There was no trial, no bill of exchange, no consideration by the state of Ohio. On February 8, 2005, our petitioner sent a notice of intention to sue. It went to the Ohio C.S.P.C. They never responded. Alright? Grounds for which release may be granted. Okay? By the authority of the Great Seal, Moorish national government, and divine providence, I, Sultan Shaheed assert my full sovereign power as a free Moorish natural being, pursuant to wit, the free Moorish Zodiac Constitution, the Great Seal, the 1833 Moroccan Treaty of Peace and Friendship, the 1790 SUNDRY Free Moor Act, the 1791 Organic United States Constitution, the United Nations Universal Declaration of Human Rights, 1948, the United Nations Draft Declaration of the Rights of Indigenous People, the Foreign Sovereign Immunity Act, Title 28 United States Code, 1604, the Declaration of Independent Action of the Second Continental Congress, July 4, 1776. 1. The Organic 1791 United States Constitution, Republic Constitution, is the supreme law of the land and all treaties. Article 6, Section 2, the United States Constitution state that this Constitution and the laws of the United States will should be made in pursuant thereof, and all treaties made or will should be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby anything in the Constitution or laws of anything of any state to the contrary notwithstanding. United States Code Title 4, Chapter 1. And any law that is repugnant to the Constitution is null and void. United States Supreme Court case, MARBURY v. MADISON, 5 United States, 1803. Chief Justice John Marshall declared that any conflict between the Constitution and a law passed by Congress, the Constitution must always take precedence. Furthermore, Article 3, Section 1, United States Constitution states, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges both of the Supreme and inferior courts shall hold their offices doing good behavior and shall at stated times receive for their service a compensation which shall not be despised during their continuance in office. The state of Ohio courts are de facto courts operating against the U.S. Constitution and the will of the people. Petitioner Pro Se Sultan Shaheed in his de jure capacity hereby makes the special appearance, not general appearance, to challenge the jurisdiction, establish justice, and invoke and enforce constitutional law for the relief of injuries. Petitioner Pro Se Sultan Shaheed is a free sovereign Moorish indigenous freehold by inheritance, free man, not a freedman resident or a person that can be named in Ohio revised codes. The Ohio Court does not have jurisdiction over Sultan Shaheed for the term person does not include the sovereign. Persons as defined in the Ohio Revised Code. Persons means the state, any political subdivision, any other state or local body, the United States, and any person as defined in Section 159 of the Revised Code. United States Code v. Cooper Corporation, 1941. The government admits that often the word person is used in such a sense as not to include the sovereign. Petitioner Pro Se Sultan Shaheed is not the person named in any of the Ohio Revised Codes stated in the court order of child support and wage garnishment. Yik Wu and Wu Lang v. Hopkins, 1856. Sovereignty itself is of course not subject to law, for it is the author and source of law. Built in our system, while sovereign powers are delegated to the agencies of government, sovereignty itself remains with the people, by whom and for whom all government exists and acts. The Declaration of Independent Action of the Second Continental Congress, July 4, states, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that amongst these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted amongst men, deriving their just powers from the consent of the governed. According to the following statement, government must have the consent of the governed to issue a child support order and an order of garnishment of wages. The state of Ohio never had a bill of exchange, and there was no consideration to the false contract. There is no jurisdiction by the state of Ohio. Where a court is without jurisdiction, its acts and proceedings are void. This court should take mandatory judicial notice that where a court is without jurisdiction in this particular case, its acts and proceedings can be of no force, of validity, and of mere nullity involved, not voidable even prior to reversal, whether the lack of jurisdiction appears on the face of the record or by proof outside of it, whereby rendering any court order issue non-involved." Maine v. Tucker, 1980. The law provides that once state and federal jurisdiction has been challenged, it must be proven. And further, this court should take mandatory judicial notice of the abridged decision of these cases. Now I'm going to pause right here, and in part 2, I'm going to give y'all the rest of it. Peace.